on civil liberties and civil rights by moving to Chapter 5, which is civil rights. But again, I want to clarify the definition, the differences between civil liberties and civil rights. So civil liberties are limitations on the government's ability to interfere with individual areas that are basically constitutionally protected from government interaction. Okay, so liberty is limits on government interference, protection from the government, versus civil rights, which is obligations or requirements for the government to take a positive action or do something for people or for individuals. So liberties, limited government. Rights are a positive action that protect people from illegal action by the government and or other private individuals. So, civil rights. Rights are often achieved through social movements. Social movements are usually a sustained campaign promoted by or on the behalf of disadvantaged groups with some type of political or social goal in mind. The effectiveness of these social movements tends to come from enabling these individuals to engage in collective actions. Collective actions is when a group or groups of people who organize and act based on a shared goal together. So you've got, as you know, the more that come together, the more able they are to activate or create change. So they work together based on some kind of a shared goal. So they're trying to raise awareness or concern or get public support behind some kind of some sort of an injustice or perceived injustice. So groups use different strategies and different tactics when they have these kinds of civil rights types movements. We classify them into fairly broad categories. Okay, you've got the inside strategy movements, is when leaders work inside or with political leaders or in the political system to try to achieve their goals. It's like passing legislation to get a statute passed or a court order or a court case to go in your favor. Outside strategy or outsider strategies are organized to try to just transform public opinion. So those tend to be peaceful protests, sit-ins, for example. So where do we find a lot of our civil rights protections, or when did they really start occurring? So the 14th Amendment guarantees civil rights to citizens, and it guarantees equal protection under the law through the Equal Protection Clause, which says, no state shall make or enforce any law which shall deny to any person within its jurisdiction. So it's speaking specifically to states. No state shall make or enforce any law which shall deny any person within its jurisdiction equal protection of the law. Okay, so equal protection of the laws means that certain groups maybe didn't have protections and they have, but it's evolved over time. Groups that weren't originally considered under the 14th Amendment as having equal protection of the law does now. So, but we need to go back in time, look as to where the basis of the 14th Amendment. And if you look at the history of the United States, it is basically a history of the evolution of civil rights. The United States has had a history of enslavement, racial discrimination, discrimination in the sense that the use of an unreasonable or what some would say is an unjust criterion to exclude or prohibit others from access to some of those rights. So when the framers accepted the institution of slavery, in essence, they embraced a system that was inconsistent with what we talked about in the early weeks of this course, which was this tradition of liberty and equity. After the Civil War ended in 1865, as the Civil War was ending, but after the Civil War, 1861 to 1865, that's when the Civil War occurred. There was the passage of the Civil Rights Amendment. The Civil War amendments are the 13th, 14th, and 15th Amendments. Okay. They were passed in response to and because of the Civil War. So the 13th Amendment abolished slavery. The 14th Amendment is actually, some just say, a complete foundational change of the Constitution. Let me back up to the 13th Amendment. I just think this is just an interesting piece of trivia. President Lincoln, although not required, it's never happened before or since, President Lincoln actually signed the 13th Amendment before it was ratified by the states, and it is in the National Archives. If you wanted to go in and look at the 13th Amendment with his signature on it. As you know, he was assassinated in 1865. So the 14th Amendment was in 1868, and that established it established citizenship, which guaranteed equal protection of the law as well as some due process. The 15th Amendment gave African American men the right to vote, and that's because many of them fought during the Civil War. So even with all of these amendments, there was still some significant resistance regarding equality. These amendments did not create equality. So in an effort to follow up and double down on these particular three amendments, because there was still so much resistance, Congress came back 10 years after the Civil War and passed the Civil Rights Act of 1875. It was intended to protect African Americans from discrimination that were using public accommodations. The Supreme Court, interestingly, found that law to be unconstitutional, and they struck down that congressional act, and the North eventually withdrew troops from southern states, which instituted a beginning of what is called Jim Crow laws. They were created to continue this social, political, and economic discrimination. And in 1896, so quite a while longer, the Supreme Court issued a ruling, Plessy versus Ferguson, which basically established this concept of separate but equal. Separate but equal meant that it was a doctrine that basically public accommodations, when we say public, we're saying, government supported or government type organizations, could be segregated by race if the facilities were equal. In essence, this allowed Jim Crow laws to continue. So from 1877 to 1950, we had over 4,000 African-American lynchings, and less than 1% of the people involved were ever convicted of a criminal offense. So clearly there were some serious issues that were still occurring. This is a picture of a drinking fountain that was a segregated drinking fountain. So the Jim Crow laws that I mentioned that came after the Civil War led to organized efforts to try to end or abolish these discriminatory laws that were happening. Some of that effort was led by a group you may be familiar with, the NAACP. They're still active today, the National Association for the Advancement of Colored People. This group was established in 1909, and they were working to win some level of political rights. They tried to achieve some level of voting, at least for African American men, and they relied on political pressure. It wasn't extremely effective, and then they started working through the courts or litigation, lawsuits, for example. But the big game changer was Brown versus Board of Education. So this is one of the most famous civil rights cases. It's also an extremely famous education course. The NCAA, the NAACP, led by Thurgood Marshall at the time, argued that that separate was not equal, and it was about Linda Brown, a young student who lived right next door to the white school, was not able to attend that school. She had to go across town to attend a school there, and working with Thurgood Marshall, her family sued, and the Supreme Court, in a unanimous decision, in fact, they put it off for a year so they could come to a unanimous decision, determined that separate is not equal. This had significant consequences on our country. Thurgood Marshall actually later went on to become a really very well-known Supreme Court justice, but they overturned separate but equal, and they looked at this situation and they said, based on actual factual evidence, okay, that the schools were not equal. They weren't even close to equal. So it was really difficult on a factual basis for the court to say that these students were being treated the same as the students that were attending the all-white schools. So consequently, the court overturned Plessy versus Ferguson, and states, this is really important, states no longer had the power to use race as a criterion for discrimination in the law. So the national government now had the power to intervene against states in discriminatory actions. Okay, so the national government now had the power to intervene against state actions that were discriminatory. So in post-Brown or after Brown, the Supreme Court relied on what is called the strict scrutiny test. You need to know this. The strict scrutiny test. Okay, so the plaintiff, the person bringing the case or lawsuit, must show what happened, but does not have to prove the law is unconstitutional. So in other words, the plaintiff had to put on evidence as to what happened. But this is flipped. This is not the plaintiff now. Instead, the defendant, which is usually the government, okay? So the government as a defendant has the full burden to prove that what they're doing is constitutional. If there's a constitutionality of a law in question, the government has to prove that what they're doing is constitutional or serves a constitutional purpose. So the strict scrutiny test, okay, the strict scrutiny test is used to prove the constitutionality of a law, and if it can't pass the strict scrutiny test, it fails and is determined to be unconstitutional. So in the post-Brown era, most states refused to cooperate with Brown, even though they came back and said separate is not equal. They found other ways to get around it. So de jure, which is you see, de jure means by law. So if by law they could segregate, that's one thing. But what happened after Brown versus Board of Education, the law no longer segregated the students. It became what's called de facto, by fact of. So schools did not come back and say that children like Linda Brown weren't allowed. They just opened private schools. They created an entirely different set of rules. So they didn't ban them by law. They just banned them by the fact that they wouldn't let them attend anymore. Not the government, but just the way that they set up the schools. Made them difficult, if not impossible. So social protests continued after Brown, this is 1954. So you start to see other protests coming about, civil rights protests, because discrimination was continuing. Discrimination in voting, in the ability to vote, employment practices, public accommodations. For example, Black people weren't allowed to stay in hotels unless it was specifically a hotel for just Black individuals. Other forms of social and economic activity continued. As a result, you start to get more really organized demonstrations. Rosa Parks, 1955, which led to the Montgomery bus boycott in 55 and 56. That was for 2 years. You see the March on Washington, D.C. In 1963, where Dr. Martin Luther King Jr. gave his famous I Have a Dream speech on the steps of the Lincoln Memorial. We have students that are sitting at Woolworth counters and other counters where they refuse to serve blacks. So you start to see these student sit-ins and the Selma and Montgomery marches across the bridge. So these were all forms of social movements. In 1964, after a lot of pressure, Congress passed the Civil Rights Act of 1964. This is extremely significant legislation. And there's different sections or acts within the Civil Rights Act. So you've got Title VI, which strengthened the executive branch's ability to desegregate schools. Title VII of the Act created the Equal Employment Opportunity Commission, saying that it was unlawful to discriminate against someone in employment by the government. Okay, I'm not talking about private, I'm talking about by the government on the basis of a person's color, race, or national origin. And this allowed the Justice Department to address employment practices, fair employment practices specifically. This is a great table. It's also in your book. Okay, so what are some of the cause and effect actions that occurred based on these movements? So here's kind of a timeline. So you'll see what Brown versus Board does, and so forth. The year after the Civil Rights Act, we get the Voting Rights Act of 1965. Extremely important. It banned the use of literacy tests as a condition to vote. If you have an opportunity, just search literacy test and see how well you would do on one of those literacy tests, and that people couldn't vote unless they could pass that literacy test. So I've tried to take the literacy test. I think I'm pretty literate. There's no way in the time limit that I could pass that test. Federal law then strengthened voting rights. So in 1965, after the passage of the Voting Rights Act, they can no longer make people pass a test to be able to vote. It made it a crime to interfere with people's right to vote. It replaced local voting registrars in not everywhere across the U.S. These were in very specific states, okay, in specific areas and counties, but they just came back and these voting registrar clerks, or the people who controlled voting, were replaced with people that were federally appointed rather than local. And we get the passage of the 24th Amendment, which abolished a poll tax. Poll meaning where you vote. So it was they made people pay to vote. Can't do that anymore. So it's the 24th Amendment. And certain states will continue to be monitored to make sure that they follow this particular act. It is important to note that in 2013, the Supreme Court case of Shelby v. Holder came back and struck down the part of the Voting Rights Act that treated some states different than others. So that's no longer in effect. Voter ID laws continue to be controversial even to today. We see a variety of voter ID laws. Some states have made it more accessible to vote. Other states have made it more difficult. You can only register like on the 5th Wednesday of a month, or they only have the voter registration clerk's office open for 4 hours once a month. Other states have done other opportunities to open up voting, mail-in voting. I would suggest absentee voting, so it depends, but we have possibly some of the most secure elections in the world. If you actually look at the facts, there's not a lot of voter fraud, but these laws are being constantly evaluated and discussed, including in our state. Well, here's another great table that's also in your book that shows you the impact of the Voting Rights Act. And it may not be the most current, just because voting changes after every election. You see some other information, but you can see how voting actually increased. You can see specifically in the states where the Voting Rights Act was being enforced. Okay, let's keep going. So let's move on to housing. Congress has tried to tackle housing discrimination. The Fair Housing Act of 1968 prohibited this discrimination in the sale or rental of most housing. That was called redlining. They would literally redline around areas that they would not sell or rent a home to certain individuals, frequently based on their race. And until the Fair Housing Act of actually enforcement in 1988, which really put some teeth into that legislation. The Department of Housing and Urban Development, commonly known as HUD, was given the ability to start to bring legal action for people. We're just going to keep going through civil rights, okay? So we could talk about police protection. In my memory, the big riots that occurred that really started to focus on police action was in 1992. Some of you may be familiar with the Rodney King riots that were in Los Angeles. Rodney King didn't pull over. They pulled him out. He was beaten. So 20 years later, we get some other incidents, and then you saw, I believe it was in 2000 when we get Black Lives Matter movements, and that came out of Ferguson, Missouri. So there's just been a series of events over time. I would suggest that this has really increased as people have had more access to cell phone videos. They can post those up on social media. It is still a major source of controversy. I believe it's going to continue to be a major source of controversy as long as people do not necessarily agree and people have access to social media. I would suggest this is going to continue to be a place that we see civil rights continue to be discussed. Marriage, civil rights and marriage. So this is a picture of a couple, Mildred and Richard Loving. This picture was taken in 1967. Okay. Richard was white, Mildred was black. Okay. The Civil Rights Act of 1964 it didn't get involved in interracial marriage, but 16 states banned interracial marriage. And in 1967, the Lovings, which were from Virginia, brought a lawsuit because they were breaking the law because they were married. The court declared that marriage is one of the most basic civil rights of man. It's fundamental to our very existence. And they struck down the laws against interracial marriage. Okay, I want to focus a little bit on gender discrimination, specifically women and the Civil Rights Act. So this Title VII of the Civil Rights Act laid out the foundation for what we would consider the modern civil rights movement. And beginning in the 70s, they started to establish gender discrimination as a major and highly visible civil rights issue. Laws and court decisions designed to deal with discrimination against women have evolved and been used to protect women against being discriminated based on their sexual or based on their orientation by the Equal Employment by the EEOC, the Equal Employment Opportunities Commission. So Women also became very organized against gender discrimination, and they sought to add the Equal Rights Amendment to the Constitution. This amendment stated, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So it passed Congress overwhelmingly in 1972, but if you remember the amendment process, we need 38 states, 3/4 of the states had to have to ratify it. It fell 3 states short of being ratified. It is interesting the time that Congress had set out for the amendment. They have a sunset clause, or from the date that it meets Congress's threshold, they have like 3 years, for example. That's a pretty normal timeline. They gave them that amount of time. They were 3 states short. Interestingly, some states came back and rescinded. One of those states was Idaho. Just so you know, there's nothing about can a state come back and change its mind. And since it's failed, other states have stepped up and passed it. But that deadline has passed anyway. So it's still being discussed whether or not it's valid. Since the ratification time has passed, I would suggest it's not, but still not enough right yet to crash that threshold of 38 states. But women have been really successful with some other victories, but these victories tend to come from the courts. So it's easier for women to file and win lawsuits than it is for them to protest and have it be effective. Or, for example, to get legislation. They tend to win based on court decisions rather than actual changing of the law or the Constitution. Okay, women have also fought for civil rights in employment, especially as we look at pay, or some would say pay discrimination. There are a lot of exceptions, to the point that sometimes exceptions become more important than the actual rules. There's the Lilly Ledbetter Pay Act of 2009 that said that if women do equal work, they should get equal pay. Okay, I want to double down on that. Equal work, equal pay, not same pay, not equal work. I think there's a lot of confusion about that, but there's not protection for people who are not doing the same work to get the same pay. I think it's important to note that women still do not make what men make. That gap has been reduced quite significantly. It's better than it was, but probably has a ways to go. I want to clarify, it's equal pay for equal work. And it depends on the state that you live in. Some states are much more equal in what they pay women than others. So if that is something of interest to you, you might want to look at the state that you might want to move to and see how it is as far as how women are paid or how men are paid in that state. Title IX, big part of the 1972 Education Act. So this is a big piece of legislation here. Okay, it's equality in education. It prohibits gender discrimination in education. It was expanded in the case of Franklin versus Gwinnett County Public Schools, where violations could be remedied with money. So they could actually sue for a monetary award. In other words, awardees could get some financial redress if they were successful in court. Basically, all male schools that were government, okay, these are not private schools, I'm talking all male schools, were not allowed to continue. The Virginia, the case that I'm talking about with Gwinnett, that was Virginia Military Institute's policy. They did not allow women. That was determined to be unconstitutional. There are still some all-female schools, but not very many. By far, the majority of schools were male schools. You may be more familiar with Title IX because it has led to significant changes in athletics, especially college athletics, and I would even suggest high school athletics. That's where we see Title IX really having an impact. And there are still some programs like in the STEM fields where there's not as many women as there are men for whatever reasons. Okay, so sexual harassment. The Supreme Court recognizes two forms. One is called quid pro quo, okay, that to continue your employment, you have to give in to the sexual harassment, this for that, okay? This is not just for female, this is male or female, okay? I'm not talking about specifically women here. I'm talking about male or female and protections against sexual harassment in the workplace. Okay, so the first is quid pro quo, and the second one is a hostile work environment, which is offensive or intimidating employment conditions. Those issues are still really relevant today. In recent cases have been, you may be familiar with the US military, the Me Too movement. I'm not sure that we're going to necessarily see those go away anytime soon either. Okay, let's look at some, we're going to switch away from gender and race gender and sexual identity to some different groups. So let's talk about Latinos, Hispanics. In 1974, there was a case, and this was actually a Chinese student, Lau v. Nichols, but it established this concept that the government has a duty to provide instruction to students who only understand in their own language. That's a really important case. It has a much bigger impact on our Spanish-speaking students. And then we've got the DREAM Act. That was a proposal that would provide a route to permanent residency. Again, that's we're still working through a lot of these. So immigrants and civil rights. And it's a civil rights issue. What is the government's responsibility? So the Supreme Court has ruled that it is unconstitutional to deny unauthorized immigrants the ability to get an education and emergency medical care. When I say an education, that's usually K-12. Okay, there's no obligation after K-12 or emergency medical care, but they can be denied other services. In 2014, President Obama issued an executive order that granted a kind of a quasi-legal status, which is the DREAM Act, okay, of children who were brought here when they were little. And that, like I said, it's very controversial today. I think it's going to continue to be a political issue. Asian Americans and civil rights. The term Asian American is going to accompany, it encompasses a wide range of people of different national and cultural backgrounds. In the 1850s, when they're building the railroad, a lot of Chinese workers were brought over. In 1870, Congress declared that these immigrants were ineligible for citizenship. And in the case of Wong Kim Ark, he was born in the US and was granted full citizenship, but that was based on the 14th Amendment, okay? So that is a very big court case that's being discussed today. So Chinese immigrants were not allowed to become citizens, but when they had children here, that's how Wong Kim Ark sued and said, I was born in the United States, and based on the 14th Amendment, I am a citizen. And that case was decided in 1898. That's a very old case. Still controversial. Well, it wasn't, but it is currently. More on Asian Americans. Japanese Americans have faced some pretty difficult discrimination, especially during World War II. There were about 120,000 that were removed forcibly from their homes and their properties and moved to internment camps. Actually, one of those was just Twin Falls, up here in Twin Falls, a Minidoka camp. The conditions in these camps were poor, bad, not good conditions. They were basically in prison. The majority of these people were Americans by blood and or birth. These camps were not closed until 1944. But many of the young men that were in these camps actually went on and served very honorably and were really incredibly decorated in World War II. Anyway, in 1988, the federal government acknowledged what had happened to these Japanese Americans, said it was a grave injustice, and a mistake had been made. Native Americans and civil rights. Native Americans are both American citizens. They are citizens of their state, they're citizens of the country, and they are members of their tribe, their tribal nation. So when we talk about tribal nations, these are tribal nations that have been recognized by the federal government, Congress. So some of the different laws that have happened or acts that have happened for them: the Indian Self-Determination and Education Assistance Act, the Lau case that we talked about, which established their right to be taught in their own language, that we talked about a little earlier with Latinos. This was a major change because if you're familiar with the Bureau of Indian Affairs, they call it the BIA. The BIA prohibited Native Americans from speaking their native language, but that is not the case any longer. It's unconstitutional. The Supreme Court in 1987 opened up some of this tribal sovereignty, which is why there's gambling allowed. You see a lot of gambling in casinos on tribal land in states that don't allow it because those tribes are considered sovereign. Disabled Americans has been a major civil rights movement. The history of advocacy for civil rights for the disabled Americans really kind of started got steam in 1973 with the Rehabilitation Act, which outlawed discrimination against individuals with disabilities. This was followed up with the Americans with Disabilities Act of 1990, which guarantees equal employment rights and access, the ability to get into public businesses, and it just prohibits the discrimination from them getting fair housing, employment, health care, some basic human dignity. Arab, Middle Eastern, and Muslim Americans have had some discriminatory issues. After 9/11, the U.S. launched its war on terror in Afghanistan and Iraq, and Americans that were perceived, whether they were or not, to be Arab, Middle Eastern, were shunned. Muslims faced increasing discrimination, and the term Islamophobia became common. And in fact, just in 1 year, from 2000 to 2001, there was over a 1,600% increase in discrimination against Arab, Middle Eastern, and Muslim Americans. Okay, let's talk a little bit about LGBTQ plus and civil rights. We've seen recent advancements in this. In 2003, there was a court case. If you're noticing, this tends to be coming through court cases, okay? It's not through Congress, it's not through legislation, it's court cases, okay? Where the Supreme Court overturned a Texas case. It's the Bowers case, okay? Which ruled against the right to privacy that protected consensual homosexual sex between consenting adults. In essence, the Lawrence case overturned a Texas statute and a previous Supreme Court case that criminalized intimate sexual conduct between these consenting parties of the same sex. And then in 2015, under the Equal Protection Clause of the 14th Amendment, we get Obergefell v. Hodges, which ruled under the Equal Protection Clause that same-sex couples had the right to marry. Controversial, transgender groups have pushed for equal rights. This is going on right now. We see it. They've relied on Title VII of the Civil Rights Act of 1964, which makes it unlawful to discriminate on the basis of color, religion, sex, national origin, or race. Again, Equal Employment Opportunities Commission tends to enforce this. There has been a Supreme Court case that says that the Civil Rights Act does apply to transgender individuals. Today, it's a hot button issue. Continues to be a hot button issue for many, many people, including transgender individuals in sports, transgender athletes at the college and high school level. Okay, affirmative action. I strongly suggest you understand the points that we're going to be making here in affirmative action, okay? This is going to be a long couple of slides right here because if you get what I'm saying, this is really important, okay? It involves the goal. So what is affirmative action and what's the goal of affirmative action? Okay. So remember early in this semester, in this course, the equality of opportunity, okay? Not outcomes of opportunity, but the equality of opportunity that we talked about is what we're talking about with affirmative action. And government policies and programs promoting affirmative action is to redress or address injustices against identified groups. They're trying to make special efforts to provide members of those specific groups with access to education, employment, contracting opportunities, etc. Okay. This was not even much of an interest of the national government until about the 1970s. So, deciding on the appropriate level of review, is it strict scrutiny? Is it intermediate scrutiny? Is it rational basis scrutiny? Okay. Who has the burden of proof in an affirmative action case? Okay. Who has to prove that it's discriminatory? Well, I'm going to give you different cases. And again, if you're just looking for one straight answer, that's not how it works. So the first case is the Bakke case in 1978. Okay. California v. Bakke. Bakke was a white gentleman. He applied to get into medical school, and he said he was discriminated against. So he needed to come back and say that the affirmative action quota was, or I wouldn't even say it was a quota, that the affirmative action was unconstitutional. So it was on him, it was on Bakke, but they came back and said that quotas are not allowed. Okay. Quotas are unacceptable, but having some sort of a standard of how you're going to admit students is not. Okay. So they didn't basically come back and say that affirmative action was unconstitutional. They just said you can't have a quota system. Okay. In Grutter versus Bollinger in 2003, they did apply the strict scrutiny case. It was a law school admissions. Okay, this was people who wanted to get into law school. Both of these were schools in Michigan, interestingly. And it says that extra weight can be applied to certain students' applications as long as you're not trying to meet a quota, like we're going to have 3 of these people and 2 of these people. That's a quota. But they say you can come back and say, okay, based on this information, we can apply a point system. Okay. So they came back and said that was okay. The University of Michigan lost, though in theirs, the law school was considered constitutional because they didn't have a quota. The undergraduate program was a quota, so that one was determined to be unconstitutional. Okay, that's a lot of information. We're going to go ahead and stop here, and then we will get into the next section soon.